Welcome to another edition of the Advisor's Guide to Estate Planning, where today we are going to have a great conversation and an interview, not with a financial advisor that we typically do, but instead we're going to have a conversation with Encore's new attorney partner in the state of Florida, Wes Dunaway. And so Wes is the managing partner of the Orlando office of Kovar Law Group. He has over 10 years experience in estate planning and probate. He was raised in East Tennessee, but lived in Orlando since 1997. He holds his undergraduate degree from Furman University and MBA from the Crummer. Did I say that right, Wes?
That's Crummer School at Rollins College.
Cool. And got his law degree from Florida A&M University College of Law, and was serving as the staff editor of the law review there and graduating magna cum laude in the top 3% of his class. Wes is admitted to practice law in state courts of Florida, the United States District Court for the Middle District of Florida, and the United States District Court for the Northern District of Florida. So welcome, Wes. Thank you for joining our conversation, and welcome to the Advisor's Guide to Estate Planning podcast.
Well, thanks for having me.
Yeah, and thank you for partnering with Encore. We're excited for this partnership and to help our advisors understand the value of what you can bring to the experience in working with their clients. And so I wanted to kind of out of the gate revisit the Encore process and how this works now and how this is available to all the clients that we are working on estate plans with in the state of Florida. Most of our advisors, if you're familiar with us, the process of that Encore, that with each and every estate plan we do, is that we have state specific attorney created templates that are baked into our software, that when clients answer all their questions related to what they want their estate plan to accomplish, our software populates that template document. From that spot, our team does a first level human review on every document we provide back. And we find about 20% of the time we catch little things, whether it's be spelling errors or any other nuances that we help catch and make sure there's a first level of quality control. What we found is some advisors also have asked and said, hey, I'd love to have a process where we have a state specific attorney look at these documents for the client and kind of go to that second level review. So we've created the process now where at checkout on any Florida estate plans in Encore, you will have the option to choose either a letter review from Kovar Law Group that reviews the documents with Wes as a Florida attorney and provides a summary of their review for $200. And we'll have the option where if the client would love to have a conversation with Wes and talk about their documents and have that specific state specific attorney conversation about their documents, that can be added to it for a total of $500. So that review is there. So that is now available as the process. So Wes, what I wanted to do is Encore still does that first level review. And then when this is purchased, we're going to throw it over the fence to you. You're going to log into our software. You're going to see all the clients' inputs, the answers to their question. You're going to see the document. Can you share kind of, okay, what are the things you're looking for as you're reviewing those inputs, the document, all the documents, maybe talk through each of the documents from your perspective and kind of the value you're able to deliver the client in your level of review?
Sure. So I think typically I would be working at reviewing a trust and a will, or perhaps wills for a married couple. And those, of course, would indicate how they want their assets disposed of upon death, and also have some provisions for dealing with a client that becomes incapacitated. When I'm looking at those documents, if it's just documents I've never seen before, of course, I'm going to look to make sure that they're compliant with Florida law, that they're executed properly. That's not going to be a problem with your documents because they've been drafted by Florida attorneys and have that first level of quality control. So I would probably dig a little deeper and look for, does this plan really make sense in terms of the family of the client? For example, if they have very young children, there should be some provision in the will and the trust to keep money in trust until the children are old. You wouldn't want to leave a 5-year-old an outright distribution that's going to end up in a guardianship. So we would look for things like that. Also look for who the client's chosen as the fiduciary. They might have chosen a very young person as a fiduciary, and that might be okay. I've met with some clients that say, "Hey, my 20-year-old is more responsible for me." I have no doubt that they would do a great job, and that's okay. But it's something to call out that it may be something to think about. There may be an unintended consequence there. Also, among the documents, we'd be looking at a durable power of attorney. That's a document that lets someone delegate authority to another person to use in case they're incapacitated and unable to act on their own. That's especially important for somebody that owns investment property, because those things can, need to be dealt with. Can be real problems if the person that owns the property is not around to do it. And of course, the healthcare documents that lay out who's going to be responsible for making healthcare decisions for the client if they can't do it for themselves. And the living will component that, indicates if someone's in a persistent vegetative state, incapacitated with no hope of recovery, what level of medical care do they want? So yeah, I've kind of look at all those documents, and based on my experience and problems I've seen in practice, is there anything here we need to take another look at?
Yeah, that's great. Yeah, and Wes, you're already familiar with our template Florida document, and so you know that it covers the basis for Florida, and so within that realm, you're able to take that deeper dive into those areas. And so what happens then is once Wes has done his review, it adds an additional 5 days to the process here, Wes's review, and then he'll upload those back or return that letter, and it gets uploaded back into the client portal. The advisor and client get notified that his review letter is there. If someone chooses to have a conversation with Wes as well on that $500 option, once that review is up, then there's going to be an ability to schedule a call directly with Wes on his calendar to have a conversation with the client. So really, this is a lot of some clients, this is going to be really important to. This is a lot of peace of mind, sometimes for both the advisor and for the client, that they got this level of oversight. And so where that matters, it now is available for Florida clients. Maybe give us a little bit, Wes, as you've talked about that, maybe your background. Tell us, you went to law school. There's lots of areas of law you could have landed in. Why do you care about estate planning, or what is it about estate planning that mattered to you? And just maybe share with us your story.
Yeah, so actually, before I became an attorney, I worked in IT for about 10, 15 years. So I've got
Okay.
some background there, and I think that plays into the aspect of drafting the documents, because attorneys typically use drafting software like your product to draft the documents. So there was a little bit of synergy there. And once I did start doing it, I really found that I enjoyed it. And as well as that, it kind of brought me into the probate aspect of it too. So another large part of my practice is actually handling estate and trust administration and probate cases after someone's passed away and their assets are distributed. So I enjoy all of that, and it's been a good practice for me.
Yeah, that's awesome. That's an important piece. We get a lot of questions from advisors that, okay, what happens when my client dies? And we give them some resources and guidance, but the reality is that if they have a client that dies, maybe they didn't have a fully funded trust-based estate plan, and I'm an advisor in Texas, but I have a client in Florida, and my client needs an attorney. Part of our goal here is to introduce our advisors to attorneys like you, that you could step in, handle some of those things, or if there's complications, as you know, our system isn't right for every client. And so there's times and places that we're going to say, hey, if you need an attorney in Florida, contact Wes for plans that are outside of our scope. Probate and administration being outside of our scope, that you can be a resource that we're excited to be able to share with advisors, where if they're not local, they generally don't have a relationship, with an estate planning attorney across all 50 states.
Right.
And so that's a exciting part of what we're able to provide here within that experience. And so tell us maybe a little bit about Florida specifically. We do have advisors all over the country, and all states have a little bit of nuance to them. And if they're in another state, but they're helping the client get through the software and it's a Florida client, what isn't good that you could share us, and we can talk a little bit on kind of what's unique about Florida.
Okay. One unique aspect of Florida is that Florida has no estate tax and no inheritance tax. At a state level, if a Florida resident has a very large estate, then they're subject to federal estate tax, then that is
Mhm.
applicable. But many states, particularly in the Northeast and the Northwest, have actually estate taxes and inheritance taxes at the state level, even sometimes at the local level. So Florida has no income tax, no estate tax. So that draws a lot of people that you want to preserve their assets. And then to some extent, it simplifies the planning. Probably the most unique aspect of Florida in many aspects in the law, even outside of estate law, getting into real estate law and even debt collection, is Florida's homestead rules. And when I say the homestead, I just mean a house that you own and then you live in. That's what constitutes your homestead in Florida. So Florida has what's called a homestead exemption against forced sale. And what that means is that if someone has a judgment against you, they may be able to garnish or levy your assets, but they can never garnish or take away your homestead. A lot of states have some homestead exemption. Florida is unique in that it's unlimited. So it doesn't matter how valuable your homestead is, as long as it fits within the statutory requirements, no creditor can ever take it. So that's why after he was found civilly liable for the death of his wife and her friend, O.J. Simpson moved to Florida and bought a large house down in Coral Gables because he knew that no one could ever take it away from him. That's another unique aspect to Florida.
Funny, that was the example I was thinking about. That's the one time in my life that I knew from that story about, because I'm a West
Right?
Coaster. I was aware of that, the importance of that, because it was the OJ case.
Yep, yep. So, a lot of people do that. And, if a client comes to me with a creditor issue, they're worried about being sued, or someone has already sued them and has a judgment and wants to know how to protect their money, say there are a lot of different tools you could use, but the best, most surefire way is to invest money into your homestead. That's protected under our state constitution. Under a state law, that homestead exemption inures or is passed on to the heirs of the person that passes away. And it has to be family members. It has to be a spouse or blood relatives. You can't have your homestead exemption inure to somebody outside your family. But as long as you're leaving it within your family, they also get the exemption. So if you die and you have creditors, even though you're now dead, they still can't get your homestead because it's passed along to your heirs. There are some rules around the homestead in Florida that cause problems for people, though. And these rules, some people think they're arcane, and there are actually a fair number of lawyers that aren't familiar with them and can get themselves into trouble because they don't know these rules. And the reason I know this is that I've seen wills come into my office prepared by lawyers that have created an invalid devise, meaning that they've tried to do something in the will that's not allowed under Florida law. Usually what they're trying to do is to leave the homestead to someone other than the spouse when there is a spouse. So under Florida law, if you're married, a lot of people that are married own their house with their spouse together. It doesn't really come into play then because the spouse is going to inherit it anyway. But where the problem comes in is when someone tries to leave their house to someone other than their spouse. That's just not allowed. Now, there may be good reasons to do that. There may be good reasons to disinherit your spouse. It may be that you've been separated for a long time and your spouse has their own house. It may be that you've got a blended family situation and there's been some other provision made for the spouse and the person wants to leave their house to their children. You can work around those things with a postnuptial agreement, but more often than not, that's not done. So that's just something to be real careful of and something we would always look for. The other aspect of that is that you can't disinherit a minor child from receiving your homestead. So if you have children that are under the age of 18, you can't disinherit them. And that creates a problem because a lot of clients want to leave the property in trust for their minor children, their homestead property, and they may not be allowed to do that. So it may make sense for them to actually co-own the property with their spouse if they don't already do that, just because of the strict limitations on what Florida says you can do with your homestead when you pass away.
Interesting. So, as you know, kind of one of our disqualifiers is, disinheriting that's not a fit for Encore. Those are the sort of plans that we'd say, come talk to Wes in Florida about if there is a need to disinherit a child. And so within that, if they can't disinherit it, how do people get around that sort of structure if it's even if it's a second spouse as well? That they wouldn't want one child. This is outside of the scope of what Encore would do, but maybe help us understand some of that. That's interesting.
Right. Besides the homestead exemption, Florida has a variety of protections for spouses. The spouse is entitled to a life estate in the house. Let me back up. If the person that passes away has no children, then the spouse inherits the house. If the person that passes away has children from outside the marriage, then the spouse inherits a life estate in the house, meaning that they inherit the house and they can live there until they pass away.
Mm-hmm.
They're also entitled to certain exempt property, which is basically the furniture in the house and up to 2 motor vehicles. And they're entitled to what's called the elective share, meaning that they're entitled to at least 30% of the estate of the person that passes away. So that's kind of the bare minimum to where the state says you can't disinherit your spouse. But all of those things can be waived in either a prenuptial agreement or a postnuptial agreement. And I do that on occasion because sometimes clients need that planning. For example, the best example is where you've got a husband and a wife that are both very well off. And this might be a second marriage for both of them. They've got children from previous relationships that are grown. They're not going to have children together. They're both independently wealthy. They already have an established estate plan on their own. They're not really looking to commingle their affairs. And yet, if they get married, the state commingles their estates by default. That's kind of the perfect person that would benefit from a prenuptial agreement or a postnuptial agreement. So, a lot of people look at that as, oh, we're planning to get divorced. They don't want to do it for that reason. And a lot of divorce lawyers also do that sort of agreement. I look at it from the different angle. I look at it from the angle of, Florida imposes these rules on what you can do with your estate. You may have a really good reason for doing something different. Here's the way you get around those rules.
Interesting. That's awesome. That's a really valuable for advisors and as they think about planning, legacy planning and being aware of that uniqueness and where you can step in here with some value in their planning. And so let's talk about the documents themselves. As you're familiar with the Encore documents, each of these pieces, what are some of the things you've seen in your practice that are maybe pitfalls, that are things that common misunderstandings or aspects of trusts versus wills, that these pieces in the state of Florida that would be valuable for our advisors to hear?
Okay. So one thing I see that causes problems, and I should say that part of my practice actually involves probate and trust litigation. Not a huge portion, but on occasion I do become involved in trust and estate disputes. And sometimes a case comes in that looks like a routine case and it turns into a disputed case, and then I'm stuck with it. That definitely happens. And what often causes that or can lead to that is a wrong choice of fiduciary. So when I meet with clients and talk to them about estate planning, I always ask, how do your children get along with each other? How do your children get along with your spouse, particularly if it's a step parent, stepchild situation? When they tell me they want to put a particular child as the fiduciary, I'll ask, how does this child get along with the others? I want to know because I don't know how many times I've seen these estate disputes or trust disputes happen, and the people are rehashing insults and events from childhood. It's not really about anything that's going on now. It's an old grudge match, and I hate to see that in any family. And so if there's some tension in the family, then it might come out in estate administration. And it might make sense for that person to have a friend or even a professional be the fiduciary instead of burdening a child with that task if it's going to create conflict in the family. To that same extent, go ahead.
I was going to say that's a great point that we see a lot of our advisors more and more having a professional trustee option. And there are many advisor-friendly trust companies that exist that we recommend advisors consider to make that decision if there's any of that at play for a client, that they can choose a professional firm to drive that for all those reasons.
Yeah, that can be a great option. It's not for everybody because it can be expensive, and
Sure.
not every trust company will, work on a relatively small estate, but
Yeah.
for the right clients,
Yep.
it can definitely make sense. So you want to make sure the fiduciary is qualified and not gonna create conflict. Another thing that I see is with the specific gifts, and you particularly want to look at that in the context of looking down the road a little bit. Because let's say a client has a net worth of $1 million, and that's about the size of their estate that they're going to pass on. And they think, well, I'm going to make a gift to my friend of $100,000. That's a tenth of what I have. That's a generous gift, but it's leaving 90% of the estate to my children. That's probably a sensible plan. Where you can run into trouble is the client makes this plan and they don't die for another 20 or 25 or 30 years. And by the time they do pass away, they've spent down that money. And all of a sudden, that $100,000 gift is more than half of their estate. And they've shortchanged their children when that's not what they intended to do. So that's something I would want to talk about and say, maybe instead of leaving a fixed amount to this person, you might want to leave them a percentage instead. It makes more sense. That's another thing I see that can cause conflict, particularly with children who don't stay real close to their parents and stay apprised of their financial situation. I've had several occasions where the child says, I don't understand this. My parents were millionaires, and now the personal representative is telling me that this estate has only $400,000 in it. They must have stolen the money. They must be hiding the money. Something is not right here. And a lot of times it's a situation where, yes, 20 years ago, your parents were millionaires, and then they retired and they started spending down their assets, and now there's $400,000 left. I've seen that several times. So I think the lesson there is, if you can, keep your family involved in your estate planning to avoid, surprises in the future.
Yeah, this is such an important. I'm glad you shared that, because we see that as the power that a lot of our most successful advisors are experiencing is the intergenerational wealth transfer. And for advisors that want that next to have an opportunity to work with that next generation when they do inherit the assets that are left, that they've prepared them for this. And this has been a family conversation. And the visual summary is a great way to do that. The family can have a conversation about, here's what's going to happen, here's how our estate plan works. And the advisor can be a part of facilitating that intergenerational intergenerational conversation to some degree, at least to even get their clients to have it would be a win, let alone if they're involved in it. And to the degree the advisors there for the next generation after their death to help with facilitating either some levels of administration, but even just the overall portfolio that they manage for the lifetime of their clients. These are ways that, and anything good communication. I was there in my own personal story when my father died a year and a half ago, was there wasn't good communication on what his intentions were, and got to kind of live that out with his spouse, his wife that he married later in life. And it would have been easier had he just said, here's what I'm thinking, here it is, here's the outline of it. Cool. As long as I'm good with that's what he wanted, whatever he wanted, it's his decision. But that communication can really, if it falls off, it almost will create tension that may not even be necessary with a lack of it. And the advisor's role in that can be incredibly valuable. My father didn't have an advisor who helped him with estate planning, sadly, in this way. Would have been nice. He knew he was the kind of guy who didn't have an advisor at all. And so he did it himself. And so he would have benefited from an advisor in a lot of ways. Well, this is really helpful. Thank you so much for just kind of giving us a sense for you, your background, and giving value on some Florida specific things to be thoughtful of. And we're excited to partner with you and help our advisors and their clients where you can kind of step in and be available in this review process where it's valuable for end clients. And so we look forward to working with you. We'll chat more in the future, but we'll call it good here today for this conversation and this interview. Thank you so much for tuning in to the Advisor's Guide to Estate Planning. We appreciate all the advisors that partner with us and work with us, US. Remember to subscribe, leave a review, share with colleagues, friends. For any questions or feedback, email us at info@encoreestateplans.com. For information on Wes, you will find it in our knowledge base when you search Florida attorney, and you'll see the process there on how you would take part in the estate specific attorney review and learn more about Wes. And you can contact Wes directly from the link in our knowledge base.